It was a quiet Monday morning when I found the envelope tucked neatly under the welcome mat like a snake waiting to strike. The letterhead was familiar: Northwood Estates Homeowners Association. I already knew it wasn't a newsletter. Inside, a fine, $750. The stated violation: unauthorized structure disrupting uniform aesthetics. They were talking about the ramp, the one I built with my own hands so my son Aaron could leave the house in his wheelchair without risking his life. Later that afternoon, I walked to the HOA office, not to argue, just to ask for clarification. Madeline Kerr, the president, greeted me with that thin, tight-lipped smile she always wore like armor, black blazer, voice polished sharp. She didn't even glance at the letter I held out. "Northwood has a standard to uphold, Mr. Ellis," she said, folding her hands. "We can't allow unsightly exceptions. I'm sure you understand." I didn't respond. I just folded the paper, tucked it into my back pocket, and nodded once. That was the moment I knew this wasn't about paint colors or property values. It was about who they thought didn't belong. And they had just made it clear: a black man with a disabled son was at the top of their list. By Thursday, the envelope turned into a certified letter. Notice of enforcement. Immediate compliance required. They gave me 10 days to remove the ramp. 10 days or face escalating fines, legal fees, and further enforcement action. The letter came from a law firm out of town, not even local. Cold, clinical language wrapped around legal threats like barbed wire. I sat at the kitchen table staring at it, coffee gone cold beside me. The ramp was still damp from last night's rain. Aaron hadn't said anything yet, but I saw him glance out the window more often than usual. That evening, my inbox lit up. From Madeline Kerr, President, Northwood HOA. Subject: friendly clarification. The tone was sweet, too sweet. Dear Mr. Ellis, I regret that things have reached this point, but as you're aware, community standards exist for a reason. While we admire your dedication as a father, the structure in question simply does not comply. If you feel Northwood no longer aligns with your family's needs, perhaps relocation might be the more suitable path. Wishing you all the best. Warm regards, Madeline Kerr. I reread that last paragraph 3 times, each word dipped in condescension. It wasn't just a suggestion, it was an invitation to leave, pack up, move on. I didn't tell Aaron. I didn't need to. He wheeled himself over, placed his hand gently on the edge of the table. "Dad," he said quietly, "I saw the letter, and the email." I looked up. His eyes were steady, too steady for someone barely in his 20s. "Let me handle this," he said. "Please." I hesitated, not because I doubted him but because I hated that he had to grow up like this. Still, I nodded. "All right." Aaron smiled a tight, knowing smile. Then he turned toward his room. As he rolled away, I heard him mutter under his breath, "They picked the wrong kid." The courthouse smelled like old wood and cold air. It was the kind of place where dignity either held its ground or got stripped away one motion at a time. We sat at the defendant's table, Aaron beside me, quiet as stone in his wheelchair. He had a manila folder on his lap, neatly organized with tabs. His hands rested calmly on top, but I could see the slight twitch in his fingers, not fear, just readiness. On the other side of the room, the HOA took their places like they were actors in a play they had already rehearsed. Madeline Kerr, perfectly poised in her black blazer, adjusted her pearl necklace and offered a condescending glance our way. She didn't see us, not really. She saw a poor black family trying to stir trouble. When Judge Reynolds entered, the room rose in unison, and then we were off. Their lawyer, Vincent Holloway, a man who looked like he sharpened his teeth on small claims, began with flair. "Your Honor," he said, standing tall and pacing slowly, "this case is not about emotion, it is not about sympathy, it is about contract, about rules." He paused, letting his words hang like a noose. "Mr. Ellis has repeatedly violated Northwood Estates community covenants. The structure, a wheelchair ramp, was installed without prior approval, does not meet neighborhood aesthetic guidelines, and was maintained despite 3 formal warnings. Our position is simple: compliance or consequences. The judge nodded, scribbled a note. I glanced at Aaron. He didn't blink. Then came Madeline. She leaned forward, her voice just loud enough to carry across the courtroom. Is he really not bringing an attorney? She said, laughing under her breath. I suppose the boy in the wheelchair is smart enough to do it himself, hum? A few HOA board members chuckled, the kind of laugh you only hear from people who've never been held accountable. Aaron didn't flinch. Holloway continued, louder now, feeding off the room's arrogance. This isn't a playground debate, Your Honor. This is not a contest of sob stories. It's the law, and it must be upheld. We are not here to shame anyone, but let me be crystal clear: if everyone decided to build as they pleased, using whatever justification they wanted, we would have chaos. Northwood was designed to be orderly, clean, and above all, consistent. He walked to the evidence table, lifting a glossy photograph of our home. This, he declared, pointing, is the unauthorized structure. It disrupts uniform design. It was installed without approval. And it stands to this day in open defiance of the agreement every homeowner signed, including Mr. Ellis. The judge turned to us. Mr. Ellis, do you have legal counsel? I opened my mouth to speak, but Aaron beat me to it. No, Your Honor, he said clearly. I'll be representing my father. You could feel the pause ripple through the room. The clerk stopped typing. Even Judge Reynolds raised an eyebrow. Vincent scoffed. Your Honor, with respect, this isn't a school project. The young man may be eager, but this is court, not a talent show. The judge held up a hand. I'll allow it, he said. For now, proceed, Mr. Ellis. Madeline leaned back, folding her arms. Her smirk deepened. Let the child play, she whispered. Aaron didn't look at her. He simply opened his folder, pulled out a single document, and stood slowly, using the arms of his wheelchair for leverage. Then he spoke. And the tone of the room changed. But that comes later. What mattered now was this. They had laughed. They had mocked. They thought a wheelchair meant weakness. They thought brown skin meant ignorance. And in doing so, they revealed exactly what kind of people they were. This wasn't just a courtroom anymore. It was a reckoning waiting to happen. The moment Aaron spoke, the room shifted. Gone was the soft sympathy people often reserved for wheelchairs. Gone was the smugness on the HOA's faces. His voice, calm, direct, unshaken, sliced through the stale courtroom air like a blade against paper. Your Honor, he began, may I ask the witness a question? Judge Reynolds, still leaning slightly back in his chair, nodded with measured curiosity. You may. Aaron turned toward Madeline Kerr, who had just finished giving her testimony, a rehearsed monologue about standards and consistency and aesthetic cohesion. She looked down at him like she might at a student who dared challenge a teacher. Aaron didn't blink. You stated earlier, he began, that the ramp on my father's property violates community standards and was constructed beyond the approved bounds of the property. Is that correct? Madeline nodded confidently. Yes, it clearly extends past the setback lines stated in the HOA covenants. Aaron's eyes stayed locked on hers. Did you personally conduct a measurement of the structure's dimensions in relation to the property line? Madeline blinked. Excuse me? It's a simple question, Aaron said. Did you measure it? Or authorize someone to do so with proper permits and instruments? There was a pause. Holloway shifted in his seat, suddenly alert. I reviewed the photos submitted by the HOA inspection team, Madeline said, suddenly less composed. Aaron nodded once, slowly. So, no formal measurement was taken? No certified surveyor involved? No official documentation to verify your claim that the ramp crosses a boundary line? Madeline hesitated. Well, the visual inspection was sufficient. Aaron turned to Judge Reynolds. Your Honor, I move to strike the witness's claim regarding boundary encroachment as unsubstantiated opinion, not fact. There is no certified evidence to support the allegation. The judge narrowed his eyes. Motion noted. Continue. Aaron reached into his folder and pulled out a folded sheet. This, he said, holding it up, is a certified land survey conducted by Latham Pierce Surveyors, a state-licensed team, dated 2 weeks ago. It confirms the ramp remains entirely within our property lines, compliant with both municipal code and ADA regulations. He passed it to the bailiff, who handed it to the judge. The room was silent, save for the flick of pages being turned. Aaron didn't stop there. Furthermore, he said, flipping to another tab, this is a permit issued by the city inspector's office authorizing the construction of the ramp. It was filed after my father's original verbal request and approved, on record. The HOA received a copy. Holloway cleared his throat. That permit was never. Aaron cut in, voice still calm. Page 3, Exhibit B, email confirmation. Sent to the HOA compliance email. Time-stamped, read receipt confirmed. The smirk vanished from Holloway's face. Aaron turned back to the judge. Your Honor, I submit that not only is the HOA's claim unfounded, but that their enforcement action violates the Fair Housing Act's provisions regarding reasonable accommodations for individuals with disabilities. Gasps rippled through the courtroom. Even the stenographer looked up for a moment. The judge glanced over the documents again, his brow furrowed, this time not in doubt but in dawning realization. Aaron sat back slowly, his breathing steady. I'm not asking for pity, he said quietly. I'm asking for fairness, and the law is on our side. I looked at my son, my boy, and for a moment, I forgot the pain, the battles, the countless nights I stayed up wondering how I'd protect him from a world that seemed so eager to knock him down. Because now, he was standing. Not with legs. With truth. And it was taller than anything in that room. Aaron didn't rush. He flipped the next tab in his folder with the kind of patience only earned through long nights of preparation. His fingers moved steadily, almost ritualistic, like a pianist about to begin the next movement. Your Honor, he said, his voice still steady, I'd like to submit 2 additional pieces of evidence for the court's review. Judge Reynolds nodded. Proceed. Aaron held up the first document, a stamped, signed permit. This is a building permit issued by the City of Brookridge, Department of Housing and Urban Development. It explicitly authorizes the construction of a wheelchair-accessible ramp at 127 Acorn Ridge Drive, our address. The ramp's specifications were reviewed, inspected, and approved by city engineers. He walked it to the evidence table and laid it down like a checkmate. Now, he continued, according to HOA bylaws, any municipal approval for disability accommodation supersedes aesthetic guidelines, as per federal law under the Fair Housing Act, Section 804. You could feel it in the air. The temperature of the room had dropped. The legal team for the HOA, once lounging with ease, sat upright now, hands twitching, glances darting toward each other. But Aaron wasn't finished. I'm also submitting Exhibit C, he said, pulling out a printed email, highlighted in yellow. This was anonymously delivered to my home 3 days ago, postmarked with no return address. I verified the metadata with a legal email technician. It's real. And it's from the internal communications of the Northwood HOA. He paused. Then read aloud. He's just a kid, no money, no lawyer. Keep the pressure on. He'll break before this gets to court. The courtroom froze. No one moved. No one even breathed. Aaron looked directly at the judge, then turned his eyes toward the HOA table. The color drained from Madeline Kerr's face. Her lips parted as if to object, but no words came. One of the board members reached out to nudge the HOA's lawyer, Vincent Holloway, who sat frozen, his hand slowly lowering from his tie. Judge Reynolds lifted the document, skimming it quickly. His brow furrowed. Aaron continued, quieter now, almost intimate, not for drama, but because truth doesn't need volume. This wasn't about neighborhood harmony. This was a campaign planned, deliberate, and targeted against someone they assumed wouldn't fight back. Someone they believed could be pressured out of their home because of a disability and the color of his skin. His words hit harder than any shout could have. In this email, Aaron said, voice tightening slightly, they didn't call me Mr. Ellis or the homeowner. They called me the kid. The assumption wasn't just that I'd lose. It was that I wasn't even a person worth respecting. He placed the email gently on the evidence table, beside the permit, truth, and law side by side. Judge Reynolds didn't say a word. He leaned back, eyes scanning the paper again, then turned toward the HOA side. "Mr. Holloway," he said, voice low, "do you or your clients dispute the authenticity of this email?" A beat. Then another. Vincent swallowed hard. We can't confirm that without further." "Do you deny it?" the judge asked again, firmer. "No, Your Honor," Vincent muttered, barely audible. Aaron looked down for a moment. When he raised his head, his eyes didn't hold anger, just clarity. "Your Honor, I move for immediate dismissal of all claims. The HOA's actions constitute harassment under federal protections for disabled individuals, and the evidence before this court makes their intent clear." The judge remained still for a moment longer. Then he slowly set down the papers and folded his hands. The silence was no longer awkward, it was heavy. It was the sound of a tide turning. And for the first time since this trial began, no one on the HOA side was smiling. Judge Reynolds leaned forward, his fingers steepled just beneath his chin. His eyes, sharp and unreadable, scanned the courtroom like searchlights in a fog. The document, Aaron's Exhibit C, lay flat on the bench before him, the damning words highlighted in bright yellow, like a wound left open for everyone to see. Then came the question. Simple, direct, devastating. Does the Homeowners Association wish to dispute the authenticity of this email? The room went still again. All eyes turned to Madeline Kerr. She sat rigidly in her chair, lips slightly parted, a faint tremor in her right hand betraying the otherwise perfect poise of her blazer-clad frame. Her eyes darted toward Holloway, the HOA's lead counsel, as if silently begging him to intervene, to redirect, to say something. But Holloway said nothing. He stared straight ahead, jaw clenched, a bead of sweat slowly sliding down his temple. His fingers tapped once against his folder, then stopped completely. The confidence he wore like armor at the start of this trial had cracked, and now it lay in pieces at his feet. Madeline began, her voice a dry whisper. "We can't confirm the context of that email, Your Honor." Judge Reynolds raised an eyebrow. "So you're not denying it?" "No," she said, barely audible. "We're not." The judge sat back in his chair. He exhaled slowly, the kind of breath a man takes when he realizes he's not just overseeing a civil dispute but standing at the mouth of something deeper, darker. "Let the record show," he said firmly, "that the Homeowners Association does not contest the validity of a document which contains language that appears to target a disabled resident for coercive legal pressure." He glanced once more at Aaron, who sat silently, hands folded in his lap. Then he turned to the courtroom. The evidence submitted by the defense reveals more than a petty zoning dispute. It suggests a deliberate campaign designed to burden, intimidate, and expel a disabled resident from his home, a home which, by all presented documents, is legally compliant and supported by municipal permits. No one moved. No one dared. This court recognizes that such actions, if proven deliberate and systematic, may constitute a violation of the Fair Housing Act, specifically Title VIII, which prohibits discrimination on the basis of disability. The temperature dropped like someone had opened a door to winter. Aaron sat still, expression unreadable, but the quiet weight in his posture lifted just slightly. "I am forwarding this matter," the judge continued, "to the U.S. Department of Housing and Urban Development, as well as the Civil Rights Division of the Department of Justice, for immediate review. This court recommends a full investigation into the conduct of the Northwood Estates Homeowners Association and any individuals complicit in the systemic targeting of the Ellis family." A collective gasp broke from the gallery. One of the HOA board members, a man in a checkered tie, slumped forward, head in his hands. Another, the treasurer, reached instinctively for her handbag, as though it could shield her from the impact of federal scrutiny. "Madeline?" She sat frozen, as if her own spine had turned to stone. Her perfectly applied lipstick couldn't hide the sudden ashen color beneath. "Furthermore," the judge added, turning to Aaron, "this court recognizes Mr. Aaron Ellis's conduct throughout these proceedings as exemplary. Despite being the subject of unlawful pressure and public ridicule, he has represented his father and himself with dignity, restraint, and a commanding understanding of the law." He paused. Then, with a final sharp knock of his gavel, delivered the blow that silenced the last shreds of HOA pride. All claims against Mr. Raymond Ellis are dismissed with prejudice. Court is adjourned. Bang. The sound echoed like a verdict through bone. No one applauded, no one cheered. The silence in that room wasn't celebration, it was reckoning. Aaron closed his folder slowly, not with triumph, but with gravity. He looked over at me, and I saw something flicker in his eyes, not relief, but something deeper. Justice. Not the kind that comes with handcuffs or paychecks. The kind that whispers, "They didn't break me." Madeline remained seated even after the judge stood and left the bench. Her legs wouldn't move. Her hands gripped the armrests of her chair like they might keep her from crumbling entirely. Outside the courtroom, murmurs became murmurs again. Reporters had already caught wind of the shift. Phones buzzed, cameras turned, but none of it touched us. Aaron rolled toward me. I put a hand on his shoulder. "You all right?" I asked softly. He nodded once. "They thought I'd fold, Dad." I smiled. They didn't know who they were messing with. Then I leaned closer and said it so only he could hear. "And now the whole damn country will. Because this wasn't just the end of a case. It was the beginning of a collapse. And the house they built on intimidation was coming down brick by dirty brick." Madeline Kerr didn't stand immediately after the gavel fell. She sat motionless, blinking at the now empty judge's bench like she hadn't yet processed what had happened. Her fingers clutched the edge of the table as though still hoping the wood might anchor her in a world where the HOA always won, but that world had just slipped through her hands and she knew it. When she finally stood, it was mechanical. Her legs moved stiffly beneath her designer skirt, her blazer wrinkled from the pressure of her clenched arms. The confident woman who had once tossed fines across fences like confetti now looked small. The moment she stepped into the hallway, the press was waiting. Microphones surged, cameras clicked, a dozen voices piled atop one another. "Miss Kerr, do you deny the email was yours? Are you stepping down from the HOA? Is the board facing legal action?" She raised a hand to shield her face, but there was no escape from the lens. The pearls around her neck no longer shimmered, they clung to her like chains. Her voice, once sharp and commanding, had vanished. All that remained was the look in her eyes, panic, shame, and something else. Recognition. Recognition that the boy she mocked, the family she tried to push out, had not only stood his ground but made the world watch her fall. I watched her disappear into the crowd, not with satisfaction, but with stillness. Behind me, Aaron rolled forward and stopped at my side. He didn't smile, didn't gloat, didn't even look back at the cameras gathering near the courtroom doors. He just reached out and gently took my hand. "Dad," he said softly, eyes still focused ahead, "I didn't do this to win." I looked at him. His voice was calm, but his grip was firm. "I just wanted them to stop," he continued. "Not just with us, but with the next family too. The next kid they think can't fight back." I nodded, my throat thick. We began to walk, or rather, move down the corridor, side by side. My steps matched the rhythm of his wheels. Behind us, the hallway echoed with distant questions and hurried footsteps. But in front of us? Silence. Not an empty kind, but the good kind. The kind of silence that comes after a storm has passed. The kind that carries weight not from what's said, but from what no longer needs to be. We didn't say much else as we left the courthouse. We didn't have to. Because what Aaron had done didn't need a victory speech. It was the speech. And every step, every turn of his wheels said louder than words ever could. This ends here. For good. 1 year later, the ramp was still there, solid, smooth, and lined with potted plants. Aaron had chosen himself, not as a statement, but as something softer. Something that said we belong here without needing to shout. We sat on the old wooden bench in front of the house, just beneath the shade of the maple tree I planted when Aaron was 6. Its branches had grown wide and full, like it, too, had survived something. Aaron had his laptop open, but he wasn't typing. He was watching the street, quiet, calm, a few birds weaving through the hedges. I sat beside him, a cup of tea in hand, the porch creaking gently beneath us. Across the street, the old HOA office was now a shared community space. A new board had taken over for the first time. It included neighbors who looked like us, talked like us, and most importantly, listened. There were no more surprise fines, no threats hidden behind formal language, just a new sign in the center of the community garden that read, "Northwood belongs to everyone." Two kids rode past on bicycles, their laughter trailing behind like ribbons. One of them waved as he sped by. "Hey, Mr. Ellis," he called out. Aaron raised his hand in return, smiling gently. "Hey, Jamal." I looked down at the base of our porch at the small wooden plaque Aaron had carved himself months ago. It was worn smooth now by sun and rain, but the words remained. "Kindness doesn't need permission to exist." He hadn't told anyone he put it there, but somehow, the whole neighborhood knew. We didn't talk much that morning. We didn't need to. Because silence like that shared, earned says everything. And at long last, Northwood had learned to listen.